Hello, folks. We're back here. Uh, Today, I'm going to talk to you about the Irac method, which I'm sure you have learned from Elizabeth. Irac stands for Issue, Rule, Application, and Conclusion. Before you watch this videotape, you should have watched the other two videos that I've put up there, YouTube videos, and you also should have read the materials up there and read the brief. I put a legal brief up there, which I'm going to go over with you now. I'm going to take my own legal brief that I've written on another case and go through it with you folks to give you examples of Irac that occur in that brief to give you an idea of how it's done in the practical world, and it's going to help you do your exercise. I'm also going to briefly go over the assignment that I'm giving you, which is a continuation of the Mark Sargent case that we've been researching. So with that, I'm going to begin. I'm going to begin by pulling up this brief that you should have read here. If you give me 1 second, I just need to find that here. Hold on. Okay, here is the brief that I wrote. You should have read this. This is a case about an individual who was found in a pickup truck. I believe it was a pickup truck that had been reported stolen. And the main issue of the case is issue 1, which is whether or not the defendant had knowledge that the vehicle was stolen. That is, whether or not there was sufficient evidence presented to the jury to support their finding of guilt for receiving a stolen vehicle. And as I said, it was a circumstantial case as to whether he knew it was stolen. So I'm going to now go over with you the Irac method. And I'm going to scroll down. Before I do that, you'll see the issue presented. Whether the evidence viewed in the light most favorable to the Commonwealth is sufficient to prove that the defendant possessed the vehicle he had been driving, knowing that it had been stolen. Where the defendant's proffered explanation for how he came to be in possession of the recently stolen vehicle, he had borrowed it 3 days earlier from a friend whose last name he did not know, was utterly implausible. All right, so I'm going to scroll down here. So you've read the facts here. I'm going to scroll past the facts. You should know what the facts are, basically. And we get down to my argument section here. And in my argument is where I employ the Irac method. All right. And what I have done for you, if you read the brief, you should see, you saw that. As I said right here, the yellow is where I stated the rule. All right. The issue has already been stated. I stated the issue up there on the issues part. The rule is that a person's knowledge is a matter of fact, which may not be susceptible of proof by direct evidence. In that event, resort must be had, and frequently is had, to proof by inference from all of the facts and circumstances developed at the trial. That is the rule. It's a very broad rule. It's not very helpful. It's not very specific, but we just take all of the facts and circumstances and we put them together to determine, to see whether or not there's enough there for the jury to infer that this fellow had knowledge, because people seldom go around admitting their crimes. They seldom go around admitting, yeah, I knew the car was stolen. We have to get inside the person's head and see, to try to determine what he knew. So that's one statement of the rule. Down here is another statement of the rule. As I said here, these are the jury instructions in yellow here. These are more specific, but these are very, this is the law stated in very plain terms to jurors. It's designed to be easy to understand. And this script that the judges use is taken from the cases, as I said there. All right. Here's a writing tip for you here. Down here, I put for you. So beginning with this paragraph here, this is where I start my analysis or argument. We call it argument because in my position as an advocate in this particular case, I am advocating a position for the government. I'm not writing a memo for a lawyer in a law firm looking at both sides and trying to find out whether or not there's a viable argument. I'm making an argument. Anyway, you notice here that I start my analysis section with the facts and circumstances that support the inference that the defendant knew the car was stolen, he was driving was stolen, are as follows. Notice I use that phrase, the facts and circumstances. Where does that come from? We go back up here And it comes right here. It comes from right here, the rule. A person's knowledge is a matter of fact which may be not susceptible of proof by direct evidence. In that event, resort must be had and has had, et cetera, by all the facts and circumstances developed at the trial. That's the key, all the facts and circumstances. So anyway, that's how I start my analysis. Here are all the facts and circumstances. That tips off the judge who is reading this that okay, kid is must be in his analysis section here. He's talking about the facts and circumstances, so he's going to apply the facts and circumstances rule to these facts. That is a tip for you folks when you're writing for me in these exercises. I find it helpful to grab a phrase from the rule and stick it into my analysis. That way, there's no question that you're mixing. That's what analysis is. You are mixing the law with the facts. It's what you're doing. So here is what I did. If the facts and circumstances that support the inference that the defendant knew the car was stolen are as follows, and I just list them out: 1, 2, 3, 4. All the things that you might commonly use your common sense to think that he knew that they were stolen. He gives a suspicious story about this friend Jose who he doesn't know his last name and borrowed it 3 days ago, and he's nervous, et cetera, et cetera, et cetera. And you see, I keep going down here. This is all analysis here. Then I get into some more law here. You don't need to concern yourself with that. This is more advanced here, but so that's more law there. And then I go back to more analysis here. You should be able to figure that out when you read this, okay? So that is my talk about the Irac method in that memo. So on that brief. So now I'm going to turn to the memorandum that I'm going to have you write, the assignment, excuse me. So I'm going to go to that right now. Give me a second. Assignment 5. So I think I did a pretty good job of laying out in the instructions what a legal memo should look like. This is a legal memo to your boss in a law firm. This is not an argument kind of memo, or an argument kind of document. What you're witnessing with my briefs that I'm writing, those are arguments to a court. That's supporting a position. This is a lawyer that wants to, he wants to he's telling you folks, listen, I got this client coming in here. He's going to pay me 10 grand for his appeal. I want to be able to tell him we can do something for him. Look this up for me. Do we have an argument that we can make? Is there an argument that we can make for that this letter wasn't authenticated? Because that was a big part of the case. We can get that letter knocked out, then it's a weaker case, blah, 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 okay? He's asking you the question. Now, he may not like the answer to the question. It may be no, it may be yes, but it's your job to look into the law for him and come up with an answer, all right? Now, what I say in this is I am not particularly concerned with your conclusion, whether there is an argument or not an argument to be made. I am very, very concerned with your analysis, how you apply the law to the facts, okay? A page or two should be fine. I don't think there's anything else I need to really say about this, except, yeah, I think it speaks for itself. This is a first attempt. I want to see how you folks do. I think that you're all great. Everybody's very, very motivated, I can tell, and on top of things and smart. So I want to put you to the test. And if this goes well, we'll keep going. And what I may do is have another video after I do the correcting of these to talk about common issues that came up with everybody writing. Okay, trying to keep this brief. Okay, I'm going to stop there if I know how to stop here. Okay, down here. And that's it. Thank you.